Okay, thank you, Johnny. I have to admit, I sometimes think this conference was held just to see if I could hold still for 45 minutes. As most of you know, I do a presentation, I'm walking all over the place, and I like a lot of interaction. So I think this is just a test to see how I can handle this under pressure and stay controlled. So if every once in a while you want to unmute your phones and give me a little laughter or some sort of feedback, I would appreciate it. If not, though, I will just go ahead and proceed and there we go. So today, I know all of you have had a lot of experience processing claims for like vehicle claims that the counties had damage, or your buildings have been flooded, or lately windstorms, earthquakes, hail damage. And those are all property and they're called first party claims because you're a party to the addendum. And if you make a claim, you're a first party. You're a member of that pool that has the addendum. So those would all be considered first party claims. Today, we're only going to talk about third party claims. So they'd be any claims that have to do with someone else making a claim against the county, saying that the county either did something wrong, or they allowed them to slip and fall in the parking lot, or they allege negligence of a county employee. This would also include an auto accident where you're at fault, cause damage to someone else. The reason I put in parentheses no admission right there, I just wanted to make the point that when you get in, make sure you tell your county folks that when they have an accident, they should not jump out and admit liability. Just quickly, my wife got in an accident a year ago, and it ended up, she jumped out of the car and said, "It's my fault. I saw this." Anyway, she admitted liability to him, and then she got home and she explained to me what had happened, and she was not at fault in the accident. She was rear-ended, and they ended up getting an attorney and treating the 26,000 chiropractic and made a claim to my insurance company for 65,000. And we had plenty of coverage, so they handled it. But still, I think if she hadn't got out and admitted that said that she was at fault, that would have changed everything. Because in the moment, you just don't know. You're looking at from your perspective, you don't know what you did compared to what they did. So we should just get out and just say, I'm just going to tell the police officer what happened in my perspective, and let them make that decision. And then from that point, if there's questions of the gray areas, then we can handle that from there. So any liability would be public officials, your county commissioners, your county attorney, county surveyor, whatever mistakes or things they do that someone felt they were wronged, or employment liability where someone, maybe a county person, was fired or terminated and they felt it was wrong and they wanted to make a claim. So that's the area we're going to talk about. We're not going to get into first party claims at all today.
Korby?
Yeah.
Could I make one comment?
Sure.
Your comment about don't admit that you were at fault.
Sure.
And under the state statute, it's very clear that the only one that can accept or create liability on the county is the governing body. Only the governing body, the commission, can accept liability and say, yes, we were at fault. The statute goes on to say, if an individual employee or officer of the government agency takes on that liability and says, yes, we were at fault, we will pay for it, that liability becomes their personal liability. So when you explain that to your employees, just let them know that if they get out of the car and say, oh my gosh, I was at fault, the county will take care of you, don't worry, the county's going to pay for this, that could actually come out of their pocket. Thanks, Korby.
Yep, thank you, Johnny. Okay, so I went to the flow chart and I wanted you to have this so you can maybe print it off to kind of see the flow of things. But I do want to mention something, kind of a side note on the report loss. When you go into Claim Zone Reporter, I know there's been confusion on that, and it's understandably so. When you come into Claim Reporter, it brings up data loss and it brings up type of claim, and it only gives you three choices: property, liability, auto. So property is going to be anything that the county owns. It could be even mobile equipment or a building, anything but a car, anything but an auto. That would be a first party property claim. It's only if the county is going to be the entity receiving the money. There's going to be no third party getting the money. The liability would be anyone that's saying that that the county did something negligent and they've been wronged. Now, where it gets confusing is if a county person is in the auto and they get in an accident, and they hurt someone else, that's actually still going to be an auto claim. That's the one exception that's not going to be a liability claim. You're going to enter it as an auto, but then it'll be a liability claim, and the claimant will be the person that was hit, car that's hit, the person who was injured. And I know a lot of people get confused on that because we kind of have liability in two sections, one just under liability and one that's auto liability. But if we can, just keep everything under the auto liability, including the county vehicle, the county injury to the other party, or the damage that they cause. Okay, so what happens when you get a liability claim? First of all, is it the first time you find out about it, was the complaint just served on the county? Is that the first time you've heard about it? If the answer is yes, and then just immediately notify us and attach the complaint, enter the claim, and enter it to us. Those are usually federal cases because the plaintiff will not have to have necessarily filed a notice of claim or put you on notice. So they're typically federal claims. But every once in a while, we get a complaint that's just filed and they didn't do a proper notice of claim under the guidelines. So if you get a complaint, just immediately to us. If they don't, if you just hear that someone's going to sue the county or someone's made a notice of claim to you saying, hey, we're going to sue you, but they actually haven't filed a complaint. First do a in-house investigation, find out what it even is. The reason is if you go to the next box down, it says proper notice. So first, your county attorney is going to want to see if it's a proper notice of claim. They're going to then make sure, and we're going to talk about that later. So if you have a question about what a proper notice claim is, we're going to get into that in just a minute. Was the claim received within 1 year of the loss? That is very important. So that's why when you get your notice of claim, which we're going to talk about a little later too, date stamp it so we know what date you actually received it, not the day it was mailed, the date it actually was received in your office. And then if it's directed and delivered to the appropriate people within the county. And we're going to get into that a little bit later too. So that box is kind of where we're going to go for most of the presentation. So if it's, the answer ends up being though, that it was a proper notice claim, yes, received within a year and is directed to the proper people, then the county has to respond to that within 60 days. It used to be, that was just about a year ago that changed. It used to be that you just deemed denied it, the county didn't respond, and it was just considered denied at 60 days. The code has changed and we now have to, the county has to respond to it. And we're going to get into how he needs to respond as well too. So don't get, I just wanted to have you have this basic chart to lead you through it. We're going to talk about these boxes as we go further. And then once that answer has been submitted by the county attorney, they have 2 years to file a complaint from when the loss occurred, not from when you responded and not after the 60 days. So it actually shortened the amount of time that they filed a complaint by 2 years. And then it's also nice if the county attorney lets me know shortly, pretty quickly when the complaint is filed, is who on our defense team he would suggest, or we can talk about who we could have defend it. Okay, back to the if it's not a proper notice claim, the answer is no, then the claimant has the 1 year to file a proper notice claim. And if they don't, at the end of the year, we close the file. And they're barred from making a claim after that year mark. Okay, so now let's get into the little details. Okay, so when claim arises, so they have the 1 year to file a notice of claim. It has to be directed and delivered to the county clerk or designated recipient or an elected county official, executive officer, and the county attorney by hand, mail, or via email starting on Monday. So as of this coming Monday, you can start receiving them by email. And you want to make sure you check to see in your email if it was, what day it was actually received, not day that they sent it, because it'd be either burden to them to show that you received it within the year, not your burden. But if you get one and it's clearly received after the year mark, you definitely want to screenshot or at least say the email showing when it was sent, the date, time, so that we could show that it was after the year mark.
Korby, can I make a comment there?
Sure.
We argued with the legislator that pushed for that bill to be passed, that because of firewalls and things like that, now you're going to have these emails coming from law firms and things, that things in your firewalls might direct these notices of claim to your deleted folder or junk folder. If that's what happens and someone sent you a notice of claim and it ended up in junk or deleted, you need to make sure then that you document with your IT department the date that it was found in your deleted or junk mail and recovered for you, because that's going to be the date that you received it, not the date that it went into your deleted or junk mail folder. So
right, because it's on the burden of the plaintiff to show that you received it, not so it'd just be for us to be able to defend it. Okay, so the county is required to respond within 60 days. So who should respond? The county attorney. They should get with us or make sure they know a little bit about the case before they respond. And I actually, on a slide coming up, I'll show you what the county attorney should do. They'll have 2 years to file the complaint from the date of the occurrence, and those are the caps. So those are the caps currently for 2021. 779,000 per person. If multiple people in a car, then it goes up to 3 million, and then 307 for property damage. Okay, so let's go back to what the notice of claim, what's required under the Immunity Act. So first, the notice of claim should set forth the basic facts of what happened. I was walking down the street, tripped on the county sidewalk. The nature of the claim, I broke my arm. The damages incurred by the claimant, as far as damages are known. That's where they would list medical bills, that kind of thing. And then name of the government employee involved in causing the claim. So if they happen to be in an auto accident, they'd want to name who is the county person involved. The county response. Okay, so this is where the county attorney comes in. They have 60 days to respond to the claimant in writing. And all they have to show is that the notice has been received. And I think it's funny because a lot of county attorneys right now are responding to the notice of claim with and that's all it says. The notice has been received, signed county attorney. And I kind of love it. They don't give any information away, just it's been received. And that's by the statute, that's all they're required to provide. The county, now, if they believe it is the wrong entity, if for say it happened on a road that is perceived to be a county road, but the county attorney talked to the road department and said, that's not a county road, that's a city road. Then if applicable, in that case, they would then identify the other entity, say, hey, we received your claim, but just so you know, that's a city road and we have no negligence. The reason I like that is we've been named in complaints where it's on a city road and we're still named. And then we end up having to get us out of the complaint when really they would have never named us if the county attorney had just said that he knew it was a city road. Okay, so the complaint is filed in the court. They have 90 days to serve the complaint on the county. The county then uses 20 days to respond and do an answer to the complaint. If the complaint is served on an employee, it's very important that the employee puts in writing to the county to the county attorney that they want a defense provided by them. The county attorney then gives the complaint to the risk coordinator, who forwards it to us, and we assign a defense attorney to assist the county attorney in the defense of the complaint. So, because technically the county attorney is to defend the county, but so the terminology we use is we hire them to assist the county attorney. The county attorney can be involved in the choosing of that person that he may work well with or thinks has good expertise in that. And I do appreciate the recommendations. But if the county attorney doesn't know, then that's fine too. We can always advise them on that. The complaint is then answered. If it's a federal case where there's going to be attorney fees, that is the time that you want to do a Rule 68 offer of judgment. And I know we get a lot of county commissioners, especially, they call up, and sheriffs call up and say, wait a minute, you're going to answer this complaint and offer money to them. And we have to explain to them that a Rule 68 offer of judgment is not an offer to settle. It's a strategic strategy to prevent attorney fees. If the plaintiff proves damages 3-4 years down the road, and he doesn't prove damages over the amount we had offered, then they can't collect the hundreds of thousands of dollars that they incurred in their attorney fees. So we have to understand that when we make that rule of offer, we're hoping that they don't want to accept it, that they don't take it, that they say, no, that's way too low. Because if we make it even for $10 and we only get a judgment of $1, they lose out on all their attorney fees for all the years that they handled it. So it's strictly as a strategy. So we try to make the number as high as possible, but not something they would accept. And so don't look at it as we're trying to settle the claim when that happens. It's strictly a strategy. And we can talk about, if you ever have any questions about those, we can talk about those because they are complicated. We have county attorneys, we have defense attorneys that struggle with the understanding of Rule 6 offer of judgment. So don't feel bad if you have questions on that. Okay, so the complaint is answered by our attorney. He meets with the county, gets some basic information, some statements, maybe some interviews, and he files a motion to dismiss. Now, a lot of my presentation today is to give you an idea of what money is involved, because I know a lot of counties feel like they put a lot of money into this addendum or to this membership of this for this coverage, and they don't get a lot out of it. What they don't realize is the money that is being spent that they don't know, that they're unaware, and that usually is what we're spending to defend the complaints. So just to have that done, and the county attorney files a motion to dismiss, they spare $30,000-$50,000 into defense at that point. If we can't file a motion to dismiss, we then begin discovery. And that's when they do more thorough investigations, maybe take depositions, subpoena people, and those kind of things. We have experts we may need to hire. Expert witnesses, maybe an accident reconstructionist, an accountant. A lot of times accountants, we've had to actually hire them probably more than anything lately to figure out how much they actually did lose in financial damages as far as lost employment and that kind of thing. And then when we think we have the case where a judge will throw it out, we file what's called a motion for summary judgment. And if that goes well, a judge sometimes will just dismiss with prejudice, then we can be out. But still, again, by that point, we're at 85 to 100, 125,000 in defense. And you realize at that point, if we get out on motion for summary judgment, it meant that there was nothing that was disputed, that there was clear that this was basically a frivolous lawsuit against the county. So when you say, I can't believe someone's suing over this, and you think, why are they allowed to do it? unfortunately, this is the result, and it costs $85,000 to $125,000 to get there. At some point in every case, we are required to do mediation. It used to be you were not required to do that, but courts now, the judges feel they're too buried in their cases, and they require mediation. So if you get notified that we have to go to mediation, don't look at it as, oh, UCIP wants to settle. That's not the 90% of the times we go to mediation, it's because we've been required to by the courts. But you, and keep in mind, the courts want you to come to those mediations in good faith, and it is very difficult to go in good faith when you know you don't want to pay anything. You know, the commissioners don't want to pay anything, and yet you have to go, and the judge will get very forceful with me and our defense attorney on why won't you settle at least for attorney fees? Well, we don't want to, you know, what it's going to cost us to defend it, because as you see from these numbers going up and up and up, you can say, well, if you keep going, it's going to cost $50,000, so you should be able to settle for $50,000. We don't want to do that. A lot of times we want to prove that we don't want to pay these claims, because if not, they're going to go spread around the county. Hey, you trip and fall on a county property, they're going to throw $50,000 at you. I worked for an insurance company for 15 years, and that's exactly what the approach they took. They said it's worth it to get out of $15, $20, $30,000, just throw it at them and get rid of them before you even file the motion to dismiss. And I never really liked that strategy, because it just, to me, it created more claims. So in a mediation, they break you up in 2 rooms, and they tell you, have the one side present their case and to the mediator, and then we present our case. These are private, you know, nothing is ever used in trial. Anything can be said, and it cannot be used in the trial or used against, you know, moving forward. It's strictly a one shot to try to settle it. Done on time. Okay. The negotiations begin, and we sometimes settle and sometimes not. Or at that point, we decide to move ahead or move to trial. Look where we are now, 150 to 175,000 in defense. Okay, now we have trial preparation, strategy, litigation meeting if necessary. What that means is sometimes we have to go to our board to get authority if we decide we're going to settle before a trial, or just maybe in case we start seeing something comes up as we're getting ready for the trial that isn't very good. But we can either have a bench trial or a jury trial. A bench trial the only time we'd want a bench trial is if we think that the general public would not understand the facts of the case. We think the judge would understand the facts better, so he would be the one to try the case in front of. If we think we want a jury involved, like maybe a low impact auto accident, where nobody, someone treats 30,000 chiropractic, probably want a jury, because we would want a jury to say, I've been in lots of accidents and didn't even think to go to a chiropractor. That's kind of people we want on the jury. The trials can last 1, 2, 3 weeks. They can go long. Depends on the experts, how many witnesses, if there's other parties involved in the case. And then the jury, you have jury selection. The court picks people. I'm actually on jury duty notice myself right now, which they do a screening, and maybe I'm sure I'll be eliminated through that screening. So the court may eliminate you that way. If not, the plaintiff attorney and defense attorney has a chance to pick people that they feel are going to be too sympathetic to the other side and have them removed, and then the trial begins. By the end of the trial, there's a judgment, maybe, or maybe not, we win. But if at that point we're at 180 to $250,000 just in defense, and that doesn't include the judgment that gets stacked on top of that if we happen to lose. So I just wanted you to have those numbers so that as you look at it, you can see why sometimes in rare occasions we may want to settle, where we realize to go to trial we're going to be in $250,000, and we have a case that's never going to happen again. I mean, just some random strange case that we wouldn't ever see happen again, and maybe those are the worst ones that we'd want to settle and get rid of based on a business decision to not spend that $180,000 and $250,000 to get to a jury and have a trial. So there are times to settle and times not to settle, and that's our kind of our strategy as you're looking at the numbers. Unfortunately, this is where it gets very troubling, because at the end of the trial.
Korby, did you accidentally mute yourself? I can't hear you anymore.
Nope. Can anyone else hear me? Is anyone alive?
I can hear you just fine, Korby.
Okay.
I can hear you too, Korby.
I can hear you too.
Thank you. Oh,
Others
so
are
good to
saying
hear
they
your
can hear
voices.
you, so apparently it's me.
Okay, well, it's so good to hear your voices. I know I talked to you once in a while on the phone, but it's still nice to hear your voices out there. Okay, I hope this is being useful, but this is the scary part we've had happen in the last couple of years. For some reason, the courts are very sympathetic to the plaintiffs. And I guess this is why when we get those chances to vote for judges and stuff, I used to think, I don't know why we get those, but now I understand why. And it's because we're getting judges now that do not want to let the county out. And we end up having to, we lose cases or we win the case outright. We just had one where we won. The decision was written so plainly and clearly that we won. And yet, without doubt, the plaintiffs now file an appeal. And they just drag these things out. They go to the appellate court. The appellate court sometimes affirms the decision, sometimes reverses it, and sometimes it remands it for a new trial. We have one in Weber County and Uintah County that have been remanded for new trials when we've had 2 trials in one of them already. And it's just dragged out and dragged out. And we end up having a new trial, and we have this one in Uintah County that I think is, let's see, almost 9 years old. And we still don't have a decision because now they want to go back to another trial. And at this point, we are talking $600,000 to $900,000 in defense only, without a judgment. And I have to admit, the first 10 years I worked here, I never saw that. That has just been something that's just been in the last 7, 8 years, that we're spending a lot of money on defense for claims that are exceeding our $250,000. I can hardly remember any time that we made a claim to our reinsurance company for defense costs that went over our self-insured retention of $250,000. So that is something that has changed. It's really difficult on the pool to project what type of cases, like setting reserves, for example, on a case like that. It's really impossible. But we have learned a lot of certain plaintiff attorneys out there that just do not go away, and we won't go into their names right now, but you'd probably recognize some of their names. Okay, I think we're about there. I know that was I fire hydrant. I just dumped a lot of information without letting anyone answer questions. I think I saw a chat question. Let me go there and see real fast. I can hear Korby. Thank you, Mary. And thanks, Tanya. So Tanya said, it's good information. It's good to see this in the case. I mainly, wanted you to have if you can, this presentation, just have that on your, maybe print it out or something, so you kind of know what you're looking at as far as how you're going to go in a case, how much money you're going to want to spend, if there's possibility you want to settle or not. And but I think that your county attorney, it's very important that maybe you have that conversation with your county attorney, have him explain to you what a Rule 68 offer of judgment is. And if he doesn't give you a good explanation, I think that's a good time you need to discuss with your county what that would mean, because they're very, very useful tool. They're new. We even had a judge that didn't understand how the rule worked. So we want to make sure everyone is on the right page on that and realize that we're not trying to settle the case. But with that, I think I'm done unless there's other questions, and I think we're right back on schedule.